Okay, imagine that the government has put a stoplight on a street that you take to get home from work at 11 o'clock every night. On this particular night, it's a clear night and there's nobody for miles. You want to get home, get to bed, yet you're expected to stop and wait for the light to turn green. Do you have an obligation to stop? Now, it might be prudent for you to stop if you fear punishment, but that's not the question. You can see for miles, as I said, and nobody's going to catch you. Would you be doing something wrong if you went through the light? This is considered the question of political obligation. Are you obligated to do what the law tells you to do simply because the law tells you to do it? Assume that you won't get caught or that you think it's worth the risk, and also assume that nobody will get hurt. We can approach the same question from another angle. The mere fact that you've promised to do something creates an obligation to do it. If asked why you should do something, because I promised provides a morally relevant reason to make sure that you do it. And the mere fact that somebody is innocent provides a morally relevant reason not to punish that person. If you ask why somebody shouldn't be punished, because they are innocent is a perfectly good answer. But is it the case that the fact that something is illegal provides a perfectly good answer as to why it shouldn't be done? If asked why you shouldn't go through the red light to get home, does the fact that because it's illegal work the same way as because I promised in the first case, or because they are innocent in the second? Now note that there are some things that are illegal that you shouldn't do, but you also shouldn't do them even if they were legal. Rape, murder, assault, for example, if the laws were removed, they would still be wrong. Young children can understand this distinction. They know the difference between what they can do if the teacher says that it's okay and what they shouldn't do even if the teacher says that it's okay. The law gives this a fancy Latin name, mal prohibita versus mala in se. That is to say, wrong because it is prohibited versus wrong in itself. Slavery, wife beating, the abuse of a child are things that are wrong in themselves, even if they're not prohibited. But are there things that become wrong only because they are prohibited? You might have a reason to obey the law simply because it's foolish not to. People have a reason to wear a helmet when riding their motorcycles and to wear a seatbelt in their cars that have nothing to do with the fact that a failure to do so is illegal, assuming it is illegal. And making something illegal, the threatening to punish those who break the law, creates reasons to do these things. However, prudential reasons are not the types of reasons to obey the law that are relevant to political obligation. When we talk about political obligation, we're talking about things that are wrong because they are illegal. Now, just because people like to make things confusing, we have to distinguish this from something else which is called legal obligation. A legal obligation is just a legal term. It merely reports a descriptive fact that within a society, a certain type of act will be officially punished by law if one commits that act. To say that there is a legal obligation to stop at the stoplight is to say that if one gets caught running through a red light, then one will likely be punished. But the fact that one will be punished for doing something doesn't make it wrong. And by the way, if you're thinking that there's no such thing as political obligations, if you're thinking that the only reasons to obey a law is to avoid being punished or because the law happens to agree with some moral principle, well, this is a viable position to take, and we'll be looking at it in other videos. If one wants to say that political obligations don't exist, well, one still needs to be able to explain what it is that one says doesn't exist. Now, let's look at some features of this political obligation. First, it's said to be what's called content neutral. So what does this mean? Well, it says that you ought to do something because it's legally required, or not do it because it's legally prohibited. But what is it that you're to do or not to do? Well, the principle of content neutrality says that the content doesn't matter. Whatever is legally required, you ought to do, and whatever is legally prohibited, you ought not to do. Now, to add to the confusion, this must be consistent with the legitimate powers of government. If one holds that a government may not violate certain rights, such as a right to freedom of speech, then the obligation to obey the law doesn't apply to any law that's outside of the government's legitimate authority. A second thing to note about this political obligation is that the obligation to obey the law is what's called a pro tanto obligation. You'll sometimes see people refer to this as a prima facie obligation, but ultimately it means that the obligation can be outweighed. It's not absolute. So, for example, you come upon the red light like we've discussed before, but this time you have a child in the back seat unable to breathe because of an allergic reaction. Now, you may have a pro tanto obligation to stop the light, but the obligation to get the child to the hospital has more weight. This notion that you have a political obligation, an obligation to obey the law, doesn't say that one must never, ever break the law. A third thing to note about political obligation is that it's territorial. To say that you have an obligation to obey the law doesn't mean that you have an obligation to obey Colorado law when you're in New York. Nor are you obligated to obey American law when you're in France. In France, the drinking age is 18. An American who's 20 years old has no political obligation to refrain from ordering a drink in France or Germany. So now, briefly, there are 4 major theories of political obligation. 4 theories that are meant to explain the nature of one's moral obligation to obey the law. The first of these theories has been dominant through most of human history, though it's only accepted in a few scattered regions today. This theory holds that the political leaders are either chosen by God or they are the God of their community. To break the law is literally to disobey God, and since it's always wrong to disobey God, it's wrong to disobey the law. Now, I'm not going to be spending any time on this theory. It's been pretty widely discredited. For one thing, if God was choosing our leaders, it would seem that God could do a better job of it. Now, in the 1600s, 1500s, a rival theory started to gain favor that said that the people have a right to choose their leaders, and by the 17th century, it was being presented as consent theory. 2 dominant figures in presenting this theory are Thomas Hobbes and John Locke, who both wrote in the 1600s. On their accounts, governments get their power from the consent of the governed. Now, the main objection to consent theory asks, when did any of us ever give our consent? We may find some few examples of people who actually gave consent, but for the most part, none of us were asked. And even if we were asked, we could claim that we were coerced, given the harms that one would suffer if one didn't give consent. A third theory rests political obligation on the obligations of gratitude or reciprocity. You have obtained the benefit of being raised and educated by the government. It provides you with a number of goods and services. As a result, you are obligated to reciprocate by obeying the laws and paying your taxes. The objection here is that the mere fact that somebody gave you a present doesn't imply that you now have an obligation to obey their commands. And there's a utilitarian theory of political obligation. Now, utilitarianism holds that what justifies a practice or institution is that it produces the greatest good for the greatest number. For example, what justifies the institution of promise-keeping is that people living within such an institution can expect to have better lives. What justifies political obligations are the benefits that people acquire when they live in a society in which people tend to obey the laws. But of course, this depends on the quality of the laws to be obeyed. Utilitarian theories tend to run into trouble when it comes to defending rights. On a utilitarian account, the state can command any sacrifice that serves the public good. There's nothing inherently wrong with slavery or genocide or killing off those who are too old or who, because of physical or mental handicaps, are unable to make a contribution to society. Plus, it seems to imply that there's no obligation to obey the law when breaking the law has good consequences. And there's also the view that we can't find an obligation to obey the law because there isn't one. This is called philosophical anarchism. Now, philosophical anarchism isn't the same thing as political anarchism, the view that there should be no government. It simply states that the only obligations we have are prudential obligations or moral obligations. There are no political obligations. So what I've tried to provide you with here is just a brief overview of the issue of political obligation. Is there an obligation to obey the law? Future videos will look at different ideas in more detail.